Hello everyone, myself Prashant Tyagi, legal intern from team LEXIS and Company. I hope you all guys are safe and healthy. I hope you like my previous video. Please like, share, comment on my videos and subscribe our channel LEXCLIQ for getting latest updates. Today in this video, I am going to discuss the topic medical negligence in India. In this video, I am going to discuss the introduction, the components of the medical negligence, the liabilities arising out of medical negligence, the standards of the medical negligence, tests used in India for determining the medical negligence, and finally the conclusion. So let's start our video with the introduction of the medical negligence in India. Man is the only animal who believes in keeping order in his world. This was one of the reasons that he invented the concept of law. Law helped every man who suffered from an injury due to the acts committed by others to seek remedy by means of compensation or punishment to the person committing the act. It was in this time that the field of medical was developing. Since no man is perfect in this world, it is evident that a person who is skilled and has knowledge over a particular subject can also commit mistakes during his practice. Such mistakes in the medical profession may lead to minor injuries or some serious kind of injuries, and sometimes these kind of mistakes may even causes death. In such situations, there arises a need of remedy to the injured people so that justice is upheld and gave rise to the concept of medical negligence. Professional negligence, more specifically, medical negligence is a term relates to the medical profession and is the result of some irregular conduct on the part of any member of the profession of related service in discharge of professional duties. But first of all, it is essential to us to analyze what is the terms remedy, legal right, legal duty, and most importantly, negligence mean. Negligence is the breach of legal duty to care. Thus, legal duty of a person means a duty the laws give to every person to respect the legal rights of the other. Therefore, the legal right of a person can be defined as the provision provided by the law to protect the interest of its citizens. Medical negligence can be seen in various fields, like when reasonable care is not taken during operations, during diagnosis, during delivery of child with issues dealing with anesthesia, etc. Since this field is very vast, we will now ourselves in understanding the basic concepts which are essential for the negligence to be committed. We shall also look into the remedies that the law provides to these patients and on whom the burden of proof lies, and when his burden of proof shifts to the other party. Now we discuss the components of medical negligence. There are three components of the medical negligence. First, existing of legal duty. Second, breach of a legal duty. Third, damages caused by the breach. Now to understand these components, we have to discuss in detail these components. First, existence of legal duty. Whenever a person approaches another trusting him to process certain skill or special knowledge on a given problem, the second party is under an implied legal duty to exercise due negligence and is expected to act at least in such a manner as is expected in order course of his contemporaries. So it is not that the legal duty can only be contractual and not otherwise. Failure on the part of such a person to do something was incompetent, so that which would be just and reasonable tantamount to negligence. Second, breach of legal duty. There is certainly a breach of legal duty if the person exercising the skill does something which an ordinary man wouldn't know have done or fails to do, with which an ordinary prudent man would have done in a similar situation. Third, damages caused by the breach. The injury occasioned by such negligence is liable to be compensated in terms of money, and the courts apply the well-settled principle of determination of the exact liquidated amount. We must remember that no hard and fast rule can be laid down for universal application. Now we discuss liability arising out of the medical negligence. There are two types of liabilities that arising out of negligence are civil liability and criminal liability. First, we discuss the civil liability. As mentioned before, the person who possesses special knowledge and skill in a field and uses this knowledge to treat the other person, then he owes a duty of acre of other person. If a wrong is committed by him in this period, then he is liable to pay damages in the form of compensation to him. In some situation, senior doctors of the hospital authorities can also be vicariously held liable for the wrongs committed by junior doctor. Now we discuss the criminal liability arising out of the medical negligence. There may be an occasion when the patient has died after treatment and the criminal case is filed under 304A of the Indian Penal Code of allegedly causing death by rash or negligent act. The commencement or pendency of criminal trial would not act as a bar to parallel civil proceedings for recovery of money or a consumer complaint, nor can be same be stayed. But there are large number of cases where criminal and civil laws can run side by side. The two remedies are mutually executed but clearly so extensive and essentially differ in the context and consequence. The object of criminal law is to punish an offender who committed the negligence, but in civil law the object is not to punish but get to compensation from the other person. Let me discuss the damages that are provided in the situation of medical negligence are: first, damages, the compensation; second, punishment or imprisonment; third, compensation and imprisonment both. Now we finally discuss the conclusion of this all above discussed theory. In India, almost every day there is a case of medical negligence which is seen. It is seen in as big as well as in the small hospitals, clinics, dispensaries, etc. Due to the number of people are suffering in our country, the most common type of medical negligence is seen in operations and during delivery of child. A number of cases has been filed against doctors who neglectfully leave their surgical instrument in the body of the patient, etc. Still, a number of doctors leave their instrument in the stomach of patient who could be fatal. In India, doctors are treated as gods. Hence, when some kind of negligent acts are carried out by them, they think was the wish of God and don't make doctor responsible for this. Illiteracy is another big factor that is not letting our people to know what kind of wrongs are being committed in our country. Our country is facing a terrible time today as the doctors also have taken advantage of poor people and are making their service sector a profit-oriented sector and changing their vision from providing good health to gaining profits from innocent people by asking them to undergo 1,000 tests before treating them of common cold. The environment in the hospitals, like the cleanliness, etc., is also maintained by most of the hospitals, not only in rural region but also in urban region, which result in the spread of communicable disease faster and easier. I hope you like this video. I hope you like this topic. Thank you so much. Please like, share, comment on my videos and subscribe our channel LEXCLIQ for getting latest updates. Thank you so much. Stay safe, stay tuned. Have a nice day.